The purpose of today's session is introduce you to Social Work England's fitness to practice process, to explain the circumstances in which a fitness to practice referral may be made, and to highlight the points in the process where Social Work England will investigate and adjudicate upon concerns. We'll also be looking to review some case studies and answer any queries you may have. I'm now going to hand over to John Dillon, who is going to lead us through the first part of this section.
Thank you, Philippa. Good morning, everyone. It's really great to have you all here today. Thank you for joining us to give us this opportunity to talk to you about our approach to fitness to practice. This would be the point where I say it's really great to see so many faces here. Sadly, the only face I can see is my own and my slides in this strange world. But Teams does reassure me that we have about 100 people on the call today, and it's great that there's this level of interest in fitness to practice. So thank you again. Before I go into the slides, I just want to introduce my two colleagues, our two experts in fitness to practice, who will be talking to you about particular parts of our service today. So Nikki, Phil, can I just invite you both to show your faces?
Yeah, good morning, everyone. My name's Philip Bowden. I'm the Head of Adjudications here at Social Work England, and I have overall responsibility for our case examiner function and our hearings function. It's lovely to see you all this morning.
Good morning, everyone. I'm Nikki Meston. I'm Investigations Manager, so I work with the investigations team.
Thank you. So we've called the session Our Approach to Fitness to Practice, and I think it's important to note that we didn't invent fitness to practice. Fitness to practice as a concept, as a service, as a legal framework has been around for almost 30 years now. And it was developed and tended to be sort of structured and evolved through what I would call the traditional health regulators and key case law around high-profile events that happen within the health sector. So why we call this our approach is because we recognized something very important from the start of building this organization. And in fact, that recognition has become all the more clear to us during our first year of operation. And that is that social work is different to health. And the structure and the rules that guide fitness to practice have to reflect that. Now, we'll talk about that a lot more during this presentation, but fundamentally, the point that we wanted to capture is that complaints tend to be made about health professionals and referrals when an outcome arises that is unexpected. So the relationship between a health professional and a patient is usually a consensual one. And for a fitness to practice complaint to arise, something unusual has to happen, something that is not expected. That is not the case in most relationships between people and social workers. And we know that concerns can sometimes, in fact, fairly often, land on our doorstep when social workers are just doing social work, but the individual involved in that is not happy with the outcome. And we have to build a process that recognizes that and that allows us to deal with concerns of all types fairly proportionately and efficiently. So that's why we call this our approach to fitness to practice. We've taken a framework, we've benefited from some innovative new powers in our legal framework, and we've developed it and tailored it to this profession and this sector. The slide you're looking at now really summarizes our ethos as an organization. And I've talked to this slide many times, and it always seems to me when I look at this slide that it's something that's quite hard to square at face value with fitness to practice. So when people think about fitness to practice, they think about investigations, prosecutions, sanctions, lawyers. Yet what we're talking about here is collaboration, common goals, and regulating in a way that suits the profession. But I've thought about this a lot, and actually I don't think this slide is hard to square with the way we approach fitness to practice. It's apparent to us that one of the keys to the way in which we investigate cases, and Nikki will talk about this in more detail in a minute, is that we need to understand the social worker's position, and we need to understand that as soon as possible, because that helps us, first of all, to know the fundamentals of a case, whether things are disputed or not, what evidence and information we need, which witnesses we need to speak to, but secondly, the degree of remediation that's taken place, and as such, the risk that a case presents. So collaboration is absolutely key, and we've built a framework, as Nikki will explain, that in some ways mandates, but in all cases encourages communication from the start. Could we flick onto the next slide, please? And thank you. So fundamentally, this is what we're going to talk about. What does fitness to practice do? How exactly have we been established to do it a little bit differently to the fundamental approach that's been adopted over the last 30 years? And how does this reflect our key ethos and core values as an organisation? And the key point I'd want to make about this slide is, when we say what is fitness to practice for, I think it's easier to say what is it not at this stage. So first of all, fitness to practice is not a complaints process. We are not here to hear about issues that have gone wrong in service provision and to determine how we fix that. That's not the role for us. There are other organisations, there are local procedures, there's the Ombudsman, and seek to remediate problems, but that is not the purpose of fitness to practice. Fitness to practice is about receiving evidence, receiving information about a social worker, and investigating that information to determine whether it's necessary for us to use our enforcement powers in order to protect the public. And unless there's evidence that suggests to us that that's necessary, we're not here to resolve complaints. That's not a power available to us. And secondly, and perhaps even more importantly, fitness to practice is not about punishment. We don't look to punish isolated mistakes. We recognise that social workers are humans, and humans make mistakes. We also recognise, crucially, that social workers on a daily basis have to exercise professional judgment. And unlike perhaps with some medical professions, there's no manual with right and wrong answers sometimes that guides the decisions that social workers have to make. And we are not a body that's here to punish for mistakes. We are here to assess whether information received indicates a breach of standards and an impairment of fitness to practice. And again, we'll speak about that in more detail later in terms of how we make that assessment. Could we move on to the next slide, please? So just a very high level sort of summary from me as to really what's different about our approach to that of the traditional regulators, who I should say are also seeking at the moment amendments that might align their process more to what we now do. But the first of those is a very robust triage of concerns when they arise, and that relates to the point I first made, that we know that often complaints will be referred to the regulator about social workers because there's been an unwanted outcome by an individual involved in the service, and effectively the complaint is just about the social worker doing social work. So we built a rigid threshold, which Nikki will talk about in a minute, that allows us to assess key aspects of a referral that we receive, such as the severity of what's happening, whether there's any evidence to support that, or whether it's just a subjective opinion, a disagreement with a professional judgment, and what action has taken place at a local level, either through investigation or remediation, to address the concerns to such a degree that there's no indication that they might amount to an impairment of a social worker's fitness to practice. Second key point is that we've ensured that we have social work expertise available at all major decision points. Our investigators aren't necessarily social workers, but at all stages in the process, they have access when they need it to professional advice. So at our triage stage, when we're determining whether we need to investigate something, we have professional advisors that will sit on decision-making panels. Throughout an investigation, Our investigators work alongside senior social workers who will guide on where they need to go to get information and how severe some of the evidence that they receive is, and whether that points to an immediate risk. When our case examiners sit to adjudicate, one of those will always be a social worker. And if cases go to a final hearing, we always have a senior social worker on our 3-person panel alongside a chair and a lay member. We also believe in early disclosure of concerns to the social worker, and what we mean by that is that where we determine we need to investigate something, at the outset we will share everything we are able to with the social worker, because we believe that if the social worker understands why we think there may be a concern and why we feel we need to investigate, then they will be better informed to tell us what we need to know with regards to whether they accept those concerns and whether they've taken any action to address those concerns. And that's the information we need and the assurances we need in many respects to determine whether we need to take a case further. We have more options to conclude cases without the hearing. Primarily, we have some really exciting new powers that haven't been available to other regulators, that sit at our case examiner stage, that allow us to resolve things more quickly that if we were to refer it to a final hearing and prepare witnesses and all of the things that have to happen to hold a public tribunal. We have a support process for social workers and for witnesses that's end-to-end. It starts at the point where we determine that an investigation needs to take place, and it goes all the way through, including face-to-face support at hearings if things need to go to hearings, and support after the event if anyone needs it. And we have regular conversations about what we're learning. We've set up a number of advisory groups, such as a representative steering group with key members of the profession, a national advisory forum, and we have a decision review group which analyses a selection of decisions made at all stages of the process every month, identifies a learning from that, both in terms of process improvement and concerns within the sector that are relating to complaints, and takes that forward either internally or in discussions through our engagement team with the wider sector. Next slide, please. So really, if you put all of that together, we have an incredible opportunity at Social Work England to run a more proportionate, fair, efficient, responsive fitness to practice process. But it's fair to say that in our first year of operation, we haven't fully realised those opportunities. We had an incredible challenge at the start of our life with Social Work England, in that we had to transition about 1,500, more than 1,500 active investigations, read through those investigations and start moving them along to the right resolution points. And it was always my view that that was going to be a very large challenge for a new organisation, but that if we had a fair wind during the year, we'd be able to process those cases, move them on, and deal with new things that came our way. But as I'm sure you recognise, we've had anything but a fair wind in our first year. The challenges of the pandemic have meant that we've had to work in a very different way to the way we expected to. All of our teams are working from home for safety, and in some cases that's made things harder to do in this environment, such as the communication you need with investigators, and in some cases, at least for a period of time, it's made it impossible to do what we need to do. So for 7 or 8 months of the year, we haven't been able to hold hearings that resolve cases. And we've had to come up with some interesting innovations in our first year of operation to work around that and keep cases moving. It's also made it harder to investigate, so to get evidence from the profession and from the sector when everybody within the profession is facing their own challenges in terms of how to deliver services in this environment. And alongside that, in our first year, we've been surprised by the rate of new referrals we've received into the service, which has been about 35% higher than we expected, based upon activity at the previous regulator. So we've had a lot of challenges to take in. We've had to innovate, we've had to change, restructure our services, and we put all that work in place, and we believe in the second year we'll really be able to make progress to combat these challenges and to push some of the older cases that have been transitioned to us forward much more effectively. Next slide, please. So before handing over to my colleagues, just really to draw out some key points about fitness to practice that I think will be woven into what we say next. And the first is we have adapted within our guidance a key definition of fitness to practice. So what we mean when we say someone is fit to practice is that they have the skills, knowledge, and character and health to practice their profession safely and without restriction. There are 3 points I think that I want to draw out there. The first is that when we say skills and knowledge, we're talking about competence, competence within the profession. So have we received evidence that suggests that the standard required to enter the profession is no longer the standard that the social worker is operating at? And that's relatively rare. Actually, most of the concerns that we see relate to character and conduct. And that's about assessing whether a social worker, as a result of something that's been brought to our attention, may have either taken action that would damage confidence within the profession, or may have taken action that suggests to us that they may not be of the character required to assure us that actions will always be taken in the best interests of service users. And finally, health. It's important to note that we don't investigate social workers because they're unwell. When we talk about health, what we talk about is, have we received any evidence that suggests that there is a health issue that's impacting a social worker's ability to practice, and they are not managing that health issue in a way that means that members of the public are fully protected. And it's only where we have evidence of that we will potentially take action as a fitness to practice matter. Next slide, please. So this is just the final point, really, which is that, as I said before, we recognise that social workers are required to exercise professional judgment all the time, and there's no necessarily right or wrong answers to that, and we're not here to punish social workers for isolated mistakes, and we're not here to take action where there's a disagreement with a professional judgment. But what we will do, and what our decision makers will do, is use these standards, our professional standards, which are woven through everything we do within regulation, to assess whether the actions of a social worker are in some way in breach of the framework of conduct and competence that we've set out. So another way of looking at it, I suppose, is that if you, within your practice on a day-to-day basis, always aim to adhere to our professional standards as set out, then there'll never be a situation in which you are vulnerable if you make an isolated and an honest mistake. And that's the key message I want to leave you on. I'm going to hand over to Nikki now and try and work out how I turn off my notifications so it's not making that noise. And Nikki's going to talk to you in more detail about the process we apply when we receive a concern and how we investigate it.
Morning, everyone. I'll just introduce myself again for those who've joined us since. I'm Nikki Meston, I'm the Investigations Manager, and I'm going to talk to you about the triage and investigations process. Can we move on to the next slide, please? So all of the concerns that are referred to us are considered on a case-by-case basis on their own merits. Concerns can come in from a range of sources, from employers, members of the public, other social workers, or from people with lived experience of social work. Social Work England triage team act as a gateway for new concerns submitted to us and will identify whether concerns raised relate to the fitness to practice of a social worker. Where they don't, then these concerns are filtered out. The triage team identify which concerns raised pass the triage test and should therefore be passed on to the investigations team for further investigation. So it's important to note that someone telling us about a concern they've got about a social worker's fitness to practice might not automatically result in Social Work England opening up an investigation. The next slide, please. So when a referral comes in, the triage team applies the pre-triage test. The potential fitness to practice concerns are then identified, and those concerns are usually passed on to the decision-making group. And that group's made up of a registered social worker, a legal professional, and someone from the triage team. And they apply what's known as the triage test, and that determines which cases and concerns have reasonable grounds for investigating whether the social worker's fitness to practice is impaired. The pre-triage checks are the initial checks which determine the course of action that's taken with the concerns as they come in. Some concerns can be routed to other teams as needed. For example, if concerns amount to registration fraud, they'd be then passed on to the registrations team. To pass concerns on to the full triage test, they need to relate to a social worker registered in England, and the concerns raised need to relate to a statutory ground of impairment, which I'll cover in a minute. If a concern's not a matter for us, then we'll take no further action. Can I have the next slide, please? The triage test is usually applied by the decision-making group, as I've previously described, and they analyse the concerns presented to answer the question, are there reasonable grounds for investigating whether the social worker's fitness to practice is impaired? It's important to note that here that the question being asked at this stage is whether there are reasonable grounds to investigate whether there is impairment. It's not a judge of whether there is impairment at this point. Can I have the next slide, please? So as part of looking at the concerns presented to them, the DMG and the triage team will together identify the types of impairment which are demonstrated by the concerns raised for passing on to the investigations team for further investigation. These are shown on this slide and they're known as the grounds. So here we've got misconduct, lack of competence or capability, conviction or caution in the United Kingdom for a criminal offence, a criminal conviction anywhere else, which would be a criminal offence if committed in England or Wales, adverse physical or mental health. And it's important to mention here that that's relating to health conditions which impact a social worker's fitness to practice and is unmanaged by the social worker. If a social worker is ill and they're being treated, engaging in their treatment, and there's no impact on their ability to practice, it wouldn't be a fitness to practice concern. A determination by another body that the social worker's fitness to practice is impaired, being included in the disclosure and barring service list, the children's or adults list, and not having the necessary knowledge of English. Can I have the next slide, please? A social worker might not be fit to carry out their work because of their behaviour, their professional skills, their health, or their knowledge of the English language. Some examples of the types of issues that are likely to raise a concern about the social worker's fitness to practice. And this is not by any means exhaustive, but some good examples. So dishonesty, fraud, abuse of trust or position, not maintaining professional boundaries with a person with lived experience of social work. Serious breaches of a person's confidentiality or data protection requirements, failure to act in the best interests of people with lived experience of social work, and exploitation of a vulnerable person. Some other examples here: serious or repeated failings in a person's care, where a social worker's performance in their role has actually harmed people with lived experience of social work or put them at risk of harm. Health concerns that have not been managed and may affect the the safety of the people with lived experience of social work or colleagues, and other serious actions or behaviour that affect public confidence in the profession. Serious concerns can arise relating to a social worker's private life, which might not present as an obvious impact on their practice. Examples of this could be instances of domestic violence or child abuse. So if you've got concerns about a social worker's practice, we recommend that they should be raised at a local level first. But if that's been unsuccessful or the concerns are serious, you should inform Social Work England. There isn't a way really to define seriousness. It's a matter of judgment. But if the concerns are so serious that urgent action might be needed to restrict the social worker's registration, you should inform us straight away. And as the regulator, we've got the power to restrict the practice through the application of interim orders. When deciding if something is serious, it should be considered whether the social worker's action or lack of action was intentional or reckless. The degree of harm caused or that could be caused if the action was repeated should also be considered. So example of things that we can't really deal with, persistent lateness. Sorry, I'm not asking you to move the slides on, I'll remember. Persistent lateness, poor timekeeping or unauthorised leave, unless it has a direct impact on a person's care. Personality conflicts or disputes between social workers and employers or managers, providing that there's no evidence of bullying or harassment. Sickness absence unless there's evidence of misconduct, such as dishonesty, or if the social worker isn't managing their health, such that the public's at risk. General issues like being rude, not responding in a timely way, or making a decision that someone's unhappy with. Next slide, please. So even where you have instances such as those described on the previous slide, you should tell us if the behaviour or actions of a social worker have raised serious concerns about their fitness to practice, or the social worker has been dismissed or suspended, or if the social worker resigns before a local investigation finishes. Sorry. It can sometimes be difficult to distinguish between a disciplinary issue in an employment context and a fitness to practice investigation. And if you're not certain whether you should be referring something, we just ask you to get in touch with us and we'll be able to work with you to establish whether we can investigate that concern. Next slide, please. So a quick summary of triage. Fitness to practice can be about a range of issues in and out of the workplace, and it's intrinsically linked with our professional standards. The triage team are the gatekeepers of new concerns and work with the triage test to decide which concerns are suitable for investigation. We might need more information before we make a decision, and so may contact the person raising the concern during this process. Next slide, please. There are some resources on our website and the links to those are here, and you can use those to decide whether you should refer something, but we can work with you, like I said, to identify whether something should be referred or not. Next slide. So moving on to investigations now. The key overarching principles of our investigations are that we're impartial. We don't act for either side in an investigation. Our role is to gather the relevant information and manage the progress of the case as an independent party. We're fair. We seek comments from all parties in an investigation from an early stage to ensure that we're able to take account of all the relevant factors and undertake a full and proper assessment of the potential risks presented by the concerns. We'll also take into account the context around the concerns and any insight or remediation that's been taken by the social worker. We're proportionate. We're not a general complaints resolution process, and our process isn't designed to resolve disputes between social workers and people with lived experience or to punish social workers for past mistakes. We're looking to assess if the social worker's current fitness to practice is impaired. Evidence-based. We understand the challenges involved in social work and we recognise that mistakes will sometimes be made. Our process isn't designed to be punitive, as John mentioned, and it's evidence-based. As a result, in order for us to investigate a concern raised, there must be credible evidence which suggests that the social worker's fitness to practice is impaired. We're transparent. We inform parties of our process and the concerns at the outset and keep them regularly updated as the investigation progresses. We also try to manage expectations of the process. We're supportive. We acknowledge the pressures that social workers face and we appreciate the impact that the fitness to practice process can have. Our staff can recognise where an individual may need additional support and we encourage social workers at all stages of the process to access specialist support services, the details of which are on our website if needed. We're collaborative, so our rules allow us to allow the social worker an opportunity to respond to the information obtained, and we give the social worker the opportunity to provide written comments at the beginning and the end of the investigation before a decision's made. And private fitness to practice investigations are private and we don't publicise the fact that a social worker is under investigation. Have the next slide, please. So we'll contact the social worker to inform them of the fitness to practice concerns that have been raised and the process that the investigation will follow. Each case is assigned to an investigator who will be their point of contact whilst the investigation progresses. We'll also contact the complainant who raised the concerns and confirm which of their concerns are able to investigate further. And for transparency, we include a copy of the reasons for proceeding with or not proceeding with concerns in both the letters to the social worker and to the complainant. The reasons are taken from the decision-making group's decision during the previous triage process. We'll also contact the employer to let them know that we've begun an investigation into concerns about the social worker's fitness to practice, unless the concerns themselves were raised by the employer. And we'll regularly update the social worker, complainant and employer as the investigation progresses. We may need to contact any party at any time through the investigation for further information. And risk assessment. We'll also carry out a risk assessment of the concerns that have been raised, taking into consideration the seriousness of the concerns, what evidence is likely to be available. Sorry, can you move on to the next slide? Whether there's a risk of repetition of the behaviours and whether there's any risk of harm to the public, but also risk of harm to the social worker. We'll then consider if we need to make an application for an interim order to restrict the social worker's practice and protect the public. Throughout the investigation, we'll continually reassess the risk as new information is obtained, and an interim order will only be applied for when it's necessary to protect the public or where it's considered to be in a social worker's best interests. I'm going to hand over to Phil now.
Thanks, Nikki. Sorry, you caught me by surprise there. Hello, everyone. For those of you who've joined just recently, my name's Philip Bowden, and I'm the Head of Adjudications at Social Work England. I am going to turn my camera off. I apologise. I'm not trying to be rude. I've just got terrible Wi-Fi today. So please don't take any offence with that. I'm sorry. But I'm going to talk to you all about the role of our case examiners and our hearings process. So if you go to the next slide, please. So who are the case examiners? That's the first question. So case examiners are employees of Social Work England. We currently employ 5 lay case examiners and 9 professional case examiners. Their backgrounds all vary and they're all currently home-based. The lay case examiners are people who are not social workers or never have been practicing social workers, whilst our professional case examiners are all practicing social workers who all bring views of the profession to the decision-making process. Case examiners and other Social Work England employees all have a shared responsibility to make sure that the integrity of our decision-making process is maintained throughout the course of the process. The underlying principle in adjudications and that of the case examiners is that they must not be influenced, obstructed or otherwise interfered with in terms of their decision-making process. They are very much independent of the case that's presented to them by the investigators. So a fundamental part of fair adjudication on decisions is that decisions must be reasonable. They must take into account any relevant matters without regard to irrelevant matters. Sorry, can we just go back on the slides? Apologies, I think it's my fault. I think I've lost control. Go back a couple of slides.
Yes, sorry, Phil, I can't now do that because you've got control. So
I will stop control. Apologies, it's entirely my fault.
thank you. I'll try and do that.
Thank you, Philippa. Just go back a bit more. Sorry, I've clearly been too eager to get through the presentation and flicked far ahead. Just keep going back a few.
If you just bear with me because it's not allowing me to go back. So just
okay. Not a problem. Whilst then Philippa's going back for the slides, I'll carry on. So what do the case examiners do? So by the time a case has reached the case examiners, all the cases would have been thoroughly investigated, as Nikki has outlined. And at this point, it's the case examiner's duty to make a considered decision as to whether there is a realistic prospect of the social worker's fitness to practice being found impaired and what the most appropriate course of action might be. So when we talk about the realistic prospect of something, we mean whether there's a genuine rather than a remote or fanciful possibility of something being found proved at a hearing before the adjudicators. And when we talk about impairments, if a social worker's fitness to practice is impaired, it means that they may not have the skills, knowledge, character or health to practice their profession safely and effectively without restriction. So when decision makers deal with what's known as impairment, they consider whether the protection of the public or the wider public interest requires action to be taken on the social worker's registration. If the case examiners decide that there is a realistic prospect of impairment being found, they'll be asked whether there's a public interest in a hearing being held, or if there's a more suitable course of action, which is known as accepted disposal. So accepted disposal is quite a unique power to us, and John's alluded to this earlier, but essentially accepted disposal is a process that allows our case examiners to close a case without the need for a physical hearing. So this has to be done with the agreements of the social worker that's going through the fitness to practice process and it allows the case examiners to impose a sanction ranging from a piece of advice or a warning right up to a suspension. What the case examiners can't do at this stage is remove someone via accepted disposal. And if the matter is that serious and it's in the public interest to do so, the case would proceed on to a fitness to practice hearing. Accepted disposal allows us to deal with cases at a much earlier stage in the process. And for me, that's one of the huge advantages in this new power, is that actually it means less stress and anxiety for social workers having to go forward to a hearing process. This is something that wasn't previously available to the HCPC, who in their ICP process can only send things forward to a hearing or close them. So it's a really great part of the process that we're looking to employ. In terms of the actions available to the case examiners, there's a range of actions available as outlined in the slide. If the events giving rise to the concern that are presented to the case examiners, which are known as regulatory concerns, that will inform any decision made by the case examiners about current or future risks to the public. As John's alluded to earlier, the purpose of fitness to practice is not to blame or punish social workers for past mistakes or poor behaviour, and the sanction imposed by the case examiners must be the least restrictive necessary. So in terms of the options available, it may be that in certain instances we will close the case without taking any further action. This might be because there's a lack of evidence to support a realistic prospect of the concerns being proved. In some instances, we'll request further information about the investigation to ensure that the case examiners have all the relevant information available to them. As I mentioned, accepted disposal is likely to be the preferred means of closing a case where there is evidence that the social worker accepts that the fitness to practice is currently impaired, and the social worker may also be actively engaged in ongoing remedial work. And lastly, referral to a hearing results in cases where there's a realistic prospect of impairment and there's a clear public interest in having the case dealt with by way of a hearing. Referrals to hearing can also be because the regulatory concerns are so serious that there's no other way of realistically dealing with them in advance. So these could be things such as serious conviction cases or dishonesty type cases. Next slide, please, Philippa. Thank you. So this is just a snapshot in terms of the overall number of decisions that we've made this year. So the case examiners have made 580 total outcomes. Out of that, they've made a total of 280 final decisions. So for all the cases considered by the case examiners, that includes new Social Work England referrals and the legacy HCPC cases. 65% of those have been resolved without the need for a final fitness to practice hearing. And for cases inherited from the HCPC, 1 in 4 of those have had a case examiner outcome which has been resolved through accepted disposal. Again, that means those cases haven't had to go forward for a final hearing. For Social Work England cases in which we've been able to utilise the full range of our powers, 78% of them have been resolved without the need for a hearing, and we've closed 66% with a finding of no impairment. The key for me in terms of making accepted disposal work is unlocking social workers' understanding of what we mean by impairments. And it's why it's so crucial for any social worker going through a fitness to practice process to engage with us as a regulator, so we can have a full understanding of the potential issues that lie at the heart of the matter. The other thing for me is obviously making sure that the language is accessible, and I know there's obviously some comments in the chat around ensuring that the language is clear and we're not having sort of a prosecutory tone to it. So that's really crucial in terms of unlocking the potential there. Next slide, please, Philippa. So if something does go through the case examiners, then there are a range of hearings that we hold at the hearing side of adjudications, and Nikki's already touched upon interim orders. So interim order applications will be applied for on one of 2 grounds, essentially. Firstly, in cases where it may be necessary for the protection of the public, so where there's a real risk of harm to the health, safety and well-being of a service user, a colleague or a member of the public, or if a social worker was allowed to continue with unrestricted practice. Secondly, it may be in the best interest of the social worker. So in cases where a social worker has a health condition, is unwell, or maybe doesn't recognise or realise the lack of insight in terms of their practice and they need to be protected. We can apply interim orders for up to a maximum period of 18 months by way of what's known as a conditions of practice order or a suspension order. So if an interim order is applied for, we're required to review that in the first instance after 6 months, and from then on in every 3 months, until such time as the interim order is revoked or the case itself concludes and is closed. In some cases, we may need to go to the High Court to apply for an interim order to be extended beyond the 18 months whilst an investigation is ongoing. The test for the adjudicators at the review stage is whether the interim order in its current form is still necessary and required. Interim orders shouldn't be in place for any longer than absolute necessary to protect the public or the social worker. In terms of final hearings, this is what is known as sort of the fact-finding stage, where our adjudicators will determine if a social worker is fit to practice by making a decision on the facts, the grounds of the case, and whether the social worker is currently impaired. If the adjudicators find a social worker to be impaired, they have a range of sanctions available to them, from a warning right up to a possible removal from the register in the most serious of cases, where no other outcome would be enough to protect the public, maintain confidence in the profession, or uphold the standards of the profession. Removal orders aren't applicable in cases of ill health, language deficiency, or a lack of competence or capability. And in these situations, the panel can apply a suspension order up for a period of 2 years before that individual may be removed. When determining the most appropriate course of sanction, the adjudicators will always look for the least restrictive sanction available to them, and explain why a lesser sanction would not be sufficient. An example of this was a recent case where a social worker was working at an NHS trust and had accessed free patients' records over a period of time without any clinical reason to do so. In their determination of the finding, the panel issued a 9-month suspension order, and in their decision they noted that the panel observed that a conditions of practice order requires a willingness on the part of the social worker to comply with them and to remediate. And this was because attending courses and training and being subject to supervision is only the starting point. It is the demonstration of commitment to the professional confidentiality that is critical importance in cases like this. And the panel concluded that given the social worker's failure to engage with the regulatory process and the resulting failure to provide any evidence they had understood and embedded the core tenets of the profession, they had no other option but to apply conditions of practice order. They didn't feel that a suspension was sufficient in that case, and a removal would have been disproportionate. So all our final hearing decisions are made available on our website, and I'd encourage you all to go and have a read of those and to look at the types of things that the adjudicators are dealing with. The majority of our hearings are held in public, but in some instances we may hold a private hearing in cases, for example, where social workers' health is alleged, or in relation to personal private matters such as family life. Very quickly as well, substantive order reviews are reviews of sanctions imposed at the final hearing stage. So, for example, condition suspension orders will be reviewed before their expiry dates. It's important to note that social workers can call an early review of substantive order if new information has come to light, which will mean that the sanction potentially could be overturned. We also have 2 other types of hearings that we hold at Social Work England, the other one being restoration hearings, which allows someone the opportunity to come back onto the register if they've previously been removed. This can only be done 5 years after that person has been removed from the register. And also we have registration appeals, which allows someone to appeal against the decision of the regulator to refuse registration onto the register. Next slide, please, Philippa. It's also just important to note actually that the PSA have the ability to appeal any decisions that we make at the final hearing stage if they feel that the decision was insufficient to protect the public. We very much work closely with the PSA in terms of looking at learning points, and again in terms of our continuous improvements across the board and how we can make our process better. So in terms of who's involved in hearings, obviously social workers are a core to fitness to practice hearings. And the most crucial element, aside from ensuring the fairness of proceedings, as far as I'm concerned, is the engagement of social workers. Just notice a comment, PSA. So the PSA is the Professional Standards Authority. They're the overriding regulator of the regulators. So they oversee all of the current health and care regulators in the UK. In terms of social workers engaging in hearings, we know that a high percentage of social workers will be unrepresented in hearings due to the cost of employing a barrister or solicitors, or through lack of engagement with the process. But that clearly shouldn't stop them from having the opportunity or the right to a fair hearing. And as we've outlined there, they can be represented by other individuals during the course of a fitness to practice hearing. We will always write to social workers when hearings are scheduled, and provide them with a notice hearing and the bundle of information in which the case will be relied upon, that outlines the date, time and venue and what will be considered at the hearing. And although attendance at fitness to practice hearings aren't mandatory, we really do encourage social workers to engage in the process to ensure that the adjudicators who make decisions in relation to fitness to practice cases have all the right information before them, to ensure that obviously protection of the public is upheld. We fully understand that engaging in fitness to practice hearings is a very daunting and stressful process for social workers and anybody engaged in the process. And members of the hearings team will always be on hand to help with questions and to talk people through the process from start to finish. In some final hearing cases, we may call witnesses to support the allegations of a case, and that will also allow the social worker the opportunity to cross-examine those witnesses in terms of presenting their case. As I mentioned earlier, the majority of our hearings are held in public, and members of the public are invited and encouraged to attend hearings. If you'd like to observe one of our hearings, which are being held remotely at the moment, you can email us and we will send you an invite. Hopefully, of course, we'll get back to Sheffield at some point in the near future. Next slide, please. And again, some of the other hearing participants that attend hearings. So cases are presented by what's known as a case presenter. It's a representative from CAB6, our legal representatives. That's normally a solicitor or a barrister who will present the case on behalf of Social Work England. And we also have hearings officers and hearing support officers who are administrative support staff. Their primary responsibility is to ensure that the hearing is run smoothly and effectively, and again ensuring that everybody has access to support so they understand what is being asked of them and they have a full range of documents when it comes to the hearing. Next slide, please. So in terms of who actually makes decisions in relation to fitness practice cases, we have what are known, a panel, what are known as the adjudicators. So their responsibility is to ensure the decisions are fair and robust and take into account all the relevant factors of a case. So they are independent of Social Work England. Although Social Work England have recruited these individuals, they're very much separate from us as the regulator. And as with the case examiners, the adjudicators are made up of a mixture of lay people and social workers from all walks and backgrounds. So it's the chair's responsibility, for example, to ensure that hearings run according to time, and they are responsible for the overall decision making of the panel to ensure that the determination is accurate, and that the panel's decision is accessible to members of the public. We have a lay adjudicator who is very much the voice of the public perspective and the public interest, and they will bring a balanced debate to the decision-making process. And lastly, of course, we have our social work adjudicators, who are registered practicing social workers. We don't appoint social work panel members on the basis of their area of expertise, but in order to bring the knowledge and perspective of the profession to the discussions of the panel. So that's a very important sort of distinction to make. Next slide, please. We also have legal advisors in hearings, and they play a crucial part in providing points of law to ensure that hearings are run in line with our rules and regulations and to assist the panel in considering relevant case law when making decisions. They don't play a part in the decision-making process and are independent of the case. They have a very clear responsibility to ensure that they support unrepresented social workers and to ensure that they understand points of law and how the hearing process will run. So although the legal advisors aren't there to represent social worker, unrepresented social workers, we do appoint them on the basis that they should absolutely provide support and explain things in lay terms so they know what's expected of them during the hearing process. As outlined in the slide, solicitors and barristers will have at least 10 years of experience and a range of knowledge which I'll bring to the discussions. Next slide, please, Philippa. So very quickly, just a snapshot in terms of the outcomes over the first year of operation. Apologies, the slide is a bit small, but we've held 85 substantive final hearings since we went live. Obviously, scuppered somewhat in March of last year by the fact of the COVID pandemic, and we moved very quickly to adapt our hearing process so we could hold hearings remotely. We recently took part in a consultation with the Nuffield Family Justice Observatory as well around the use of remote hearings in family court proceedings. And the results were fairly balanced in terms of the positive and negative aspects of remote hearings. I'm firmly of the view that remote hearings are a good thing and allow social workers to engage in the process. For example, previously where we've had social workers based in the southwest in Cornwall, this has meant people can engage in hearings much more effectively and can dial into their hearings with relative ease. Anecdotally, I would say that the higher proportion of removal and suspension orders compared to a relatively low rate of conditions of practice and warnings has been a result of the way we've prioritised the serious cases that we've inherited from the HCPC, for example, those cases that have had an interim order in place. Next slide, please, Philippa. And in terms of employee involvement, I know there's been some questions about this in the chat, but for employees, we will keep you informed of the progress of hearings and write to you once the hearing's been scheduled and at the conclusion of the hearing. If you're an employee of multiple individuals who are being called to give evidence to the hearing, we will try to minimise any disruption in terms of spacing out your employees' attendance when they come to give evidence. The average length of a hearing is around 4 days, so we'll normally call witnesses over the first couple of days of a fitness to practice hearing. And again, we recognise that the vast majority of people called to give evidence will never have done this before, and it's a very daunting process. It likely be the first time that anybody's come to give evidence in a tribunal. So our hearing support officers are there to support both witnesses and social workers subject to a hearing through the hearing process to ensure that they fully understand. Next slide, please, Philippa. And I think lastly, from my point of view, just to say again that we recognise the emotional impact that fitness to practice cases have on everyone going through the process, and we welcome feedback in all forms. Very much a learning organisation in terms of continuing improvement and looking at reflective practice in terms of how we can better improve our processes to make them as fair and accessible to everybody as possible going through the process. We're currently doing some really good work with the NMC and other regulators around an advocacy service for witnesses, in order to provide an advocacy support service for them. And we're looking at strengthening our links with various charities and organisations such as the Free Representation Unit and Advocates to try and promote the representation of social workers in fitness to practice hearings so they can have accessibility and access to representation during the course of fitness to practice hearings. I think that's so crucial, and we'll continue to do work with those charities and organisations. I'm going to hand over to John, who's going to talk to you now about the role of case review and remediation.
Thank you, Phil. I'm conscious of time, so I'll be relatively brief on this, but I think one thing that I hope came out of what Philip was saying there is that even for the most serious cases that go through a fitness to practice process all the way to a hearing, which is only about, well, it's less than 10% of all referrals that we receive within the process. Only about 3% of those that end up at a final hearing end up with the most severe sanction, which is a removal order. It's actually the case that in less than 2% of all referrals we receive into the service, the most severe sanction is the one that we apply. And I think that's important to remember because people tend to equate fitness to practice and fitness to practice investigations simply with removal at the end. But actually, the majority of our sanctions are designed to assist social workers to address any issues that we've identified and remediate. And that's where our case review team comes in. We have created a service that we call case review, despite not being required by law to do so. So all the services we've talked about throughout the process, we're required to build by law. But the reason why we've created this extra service is that we recognise that it's not right to issue a sanction and then offer no guidance or support or monitoring to make sure that A, the purpose of that sanction is understood, and B, that social workers that do have restrictions on their registrations, suspensions and conditions of practice have access to the information that they need to know how they can address the issues and work their way out of that sanction. And primarily that's what the case review team is there to do. It also, of course, serves as an important public safety function, so that if a social worker has a sanction and we receive evidence that it's not being complied with, then our case review team will assess whether further action needs to be taken. But fundamentally, this is a service to support social workers that we recognise are going through a difficult process. Our case review officers will make contact individually on a one-to-one basis with a social worker that's gone through the difficult process of a hearing, explain exactly what their sanction means and how it will be managed during the period, which is usually somewhere between 12 months, 2 years, and explain what will happen when it comes to the point that sanction needs to be reviewed. Next slide, please. We think whilst we're not required to run this service, and the previous regulator didn't have a comparable service, we see it as a really important part of, again, going back to our ethos as an organisation, establishing a fitness to practice process that reflects our key values. And there are real benefits that we get from this service, and we've seen it already in the first year. That is really sort of maintaining a relationship between a social worker that's gone through a very difficult process and the regulator that has managed that, ensuring that there's a support network and structure in place to guide and support through that process for social workers that are eager to return to full unrestricted practice. Early identification of any problems that arise during that process, and therefore better public protection. And crucially, the objective of that service is to return social workers that are able to practice to the profession as soon as possible to ensure they are able to return to their duties. And so our case review team that sits alongside the rest of Fitness to Practice plays a really crucial role in that. And the final slide, please. That is just, and I've noticed, having watched some of the comments, there have been questions about conditions of practice. For me, this was the final slide that I wanted to finish on, because conditions of practice sum up what we're trying to say really in fitness to practice, which is that even in serious cases where we determine we have to take action, that action is not designed to be punishment. The action is designed in all cases where we think, looking forward, that the issues identified can be remediated, that we put measures in place that will assist to get there. And conditions of practice are the section that most obviously represents that. Conditions will usually contain two things. They'll contain some kind of restriction on practice, i.e. not to practice in a certain area for a period of time, alongside some kind of prescription, such as the requirement to undertake training or submit a portfolio of reflective evidence. And the two things working alongside each other allow a social worker at a review hearing down the line to demonstrate that the concerns that were apparent at the time that this order was issued are now remediated. And what we've seen in our first year through the management of this service is that, unlike at previous regulators, our success rate in terms of turning active sanctions into renewals to the register without restriction is far higher. So we intend to put a lot of effort into our support service for case review moving forward, because we think it really does capture what we're trying to achieve in fitness to practice. So I know there's a lot of information in that presentation, but I hope you all found it helpful. I'm conscious of time, but there is now an opportunity, if anyone would like to ask a question with their voice rather than down the side, to ask us that now, and if we can answer it, we will do. So please do feel free to speak up now if there's a question you have for any of us.
So Paul, I can see that you've got your hand up. Do you want to ask your question to the Fitness to Practice team?
Yeah, thank you. Just sort of throughout the whole thing, it's been very helpful, very interesting. But from the very beginning all the way through, it's been talked about how the process is not designed to be punitive, not designed to punish. But there's been quite a lot of exposure recently, I think, community care, things like that, about quite long time frames for the process without sort of the trial, so to speak, at the end of it, or a conclusion, which essentially leaves a lot of social workers feeling like there's an axe hanging over their heads, really. And there's the regular updates that were spoken about to the social worker, again, anecdotally, doesn't seem to be happening, although I appreciate complaints speak louder than the good experiences, so I appreciate that. I think there were maybe some staffing issues around it, as in not enough staff. You said about 35% higher than expected caseloads, that sort of thing. The question at the end of all this is, does Social Work England sort of recognise that the process, however it's intended to be, is felt to be quite punitive and punishing for the social workers who are going through that and seeking to alleviate some of those issues? Sorry, it was quite long.
Paul, I'll come in, but if any of my colleagues want to add, please do. That's a really fair question, and I agree absolutely that a fitness to practice process that is producing significant delays is not performing in the way that it needs to. I fully recognise, having worked in this area for a while, the strain and the the pressure that a practitioner is under when an investigation is hanging over them and it's not moving quickly. And indeed, all of our efforts are fully engaged in making sure that we are progressing cases as quickly as possible. I mentioned at the start the challenges we've had in the first year, some of them foreseeable, some of them not, but they have combined to a point where we determined in about September this year that things needed to change for us to speed up the progression of cases. And in order to achieve that, we increased capacity across the service significantly by bringing in new roles, new employees, and we restructured the service entirely, possibly temporarily during this period where things are harder to achieve, but long term, if we need to make sure that we speed things up. We have seen really good signs of progression as a result of the work we've done this year. So, for example, the timescales it takes to progress new cases through the system are far quicker than with the cases that we've inherited. But we are experiencing challenges with the volume and age of the caseload we inherited, and we've put plans in place with dedicated teams to progress that as quickly as possible through the service. It's my belief that we have the required capacity to do that, but we have to see significant progress with those cases in the next year, and we've set out our targets as to what we're aiming to achieve to hit our timescales in recent board papers.
Thank you.
John, I'm just mindful we are running out over time already, so I'm just wondering, there are a couple of people have hand up. I know that Aaron and Elena had their hand up first within those few minutes. Do you want to take those questions, or are we going to, I'm just concerned that we're already 5 minutes over.
Yeah, I'm happy to just take a couple of questions from those with their hands up, and we'll probably have to call it a day at that, but we'll obviously answer anything else in writing that anyone wants to raise.
Okay, I'm going to go next to Aaron.
Oh, thank you so much. This was quite very much insightful. Mine is with regards to, I think I also saw somebody who raised the same question. It's regarding the issue of representation, especially for the in terms of your adjudicators, knowing quite well that black and minority groups are proportionally being investigated for professional misconduct. And I think there was a response that was given that in terms of your protocols, there's nothing really in black and white in terms of that, what is being done, because I think if there's not that conscious effort, otherwise we may put this one on the blind, and it may really affect especially people from that side. So what is being done by the regulator in that regard, in terms of a conscious effort to really represent this group?
So we first and foremost, we try and operate our professionals, our processes in a way that makes them as accessible as possible. So should anybody want to engage without representation, or should they have to, that they're able to do so. And we, as Phil has said, we appoint legal professionals to the hearing whose role is not to present the case, but is to ensure that proceedings run smoothly, and essentially that is to support participants through the process and ensure they understand what's happening. Nevertheless, we do recognise that in many circumstances it is beneficial for those going through the process to have representation. We're in a tricky position because we can't appoint representatives for social workers going through the process that we are advancing. That would create legal problems. But what we are doing is working with our colleagues at other regulators right now to create a framework of representation, legal representation, that we can make anyone going through the process aware of. and we can signpost them in that direction so that legal advice may be available, legal support may be available in a cost-friendly way. That process is being worked on in collaboration with colleagues at the Nursing and Midwifery Council and other regulators, and we hope to be able to launch that process within the next year. There are representative bodies, of course, available to social workers, but we hope that work will open up a new line of opportunities for social workers that really do want to seek representation going through the process to obtain it in a realistic way.
Oh, thank you.
Thank you. I'm going to take one last question because Elena was the person who had her hand up first. So Elena, I'm going to come to you. Thank you. And I think that will be the final question we're going to take.
Thank you. Thank you very much for taking my question. I'll try to be brief. First of all, thank you, Jonathan and Philip and Nikki, for the presentation. That was really helpful. I'm here representing Suffolk. I'm Principal Practice Lead for Suffolk, and I'll probably have to email you separately and maybe ask for a meeting to discuss the certain concerns for Suffolk. But I just wanted to first of all ask whether we can have a copy of the presentation to circulate to the managers. And also with just a few questions, are you considering including some timescales for investigations? Because the main concern is they are very, very lengthy and they have a significant impact on some of the social workers. We even had cases where they are thinking leaving social work, which is really sad, particularly when, you know, those are very experienced members of staff who are very good social workers. And do you have a cut-off point for when do you stop looking for evidence in cases where that are not clear cut? So we are not talking about significant concerns that led to a disciplinary process for that social worker. We are talking about, you know, the parent says that, but the social worker says something else, and you don't have enough evidence. And the message we had was, it's just not ending. It's a never-ending process. So yes, those are my questions.
Oh, okay. First of all, on timescales, as I said before, very important that we work to improve timescales on new cases and inherited cases, and we're doing that. When people talk about timescales in fitness to practice, they usually talk about how long on average does it take for you to take a case from receipt through to conclusion at the final hearing. And the view commonly shared is that a reasonable timescale for that is something between 12 and 15 months because of all the legal processes involved. But actually, one of the focuses we have at Social Work England is not necessarily just on that timescale, which we do want to reduce, particularly for those old cases that we've inherited, but also how are you optimizing the powers you have at the case examiner stage that allow you to issue appropriate orders where necessary without a hearing? And that, in a way, is a bigger win than improving the overall timescale, because if we can optimize that, then it will take a process that would take 12 to 15 months for most social workers down to more like 6 months. So we're working on both processes together. My view is that we need to reduce our overall caseload in the next 6 months, and we have a clear plan to do that. And once we've done that, then timeliness and improvements will immediately follow. In relation to your second point, there is no simple answer to that. In terms of there isn't a sort of a statute of limitations, if you like, whereby if something hasn't been resolved within 3 or 4 years, we no longer have jurisdiction. And as a result of that, we can't stop an investigation because of the age. However, we can only take a case forward if we believe there is an indication that the social worker may be currently impaired. And it follows that the longer away we are from the event that created the referral, as long as there have been no more concerns since, then it becomes much harder for anyone to contend that a social worker is impaired by virtue of this thing that happened in 2017, particularly if there have been no problems since. So in reality, while there is no cutoff point in law, the older an investigation gets, the more difficult it becomes for anyone to argue that impairment might be indicated as a result of it. So we would not, for example, expect to be progressing a case through to a hearing if we're talking about one minor issue that occurred many years ago. Is that helpful?
It is. Thank you, Jonathan. Yes, I'll probably email you separately if that's okay to take it further.
Okay, I'm going to bring it to a close because I'm just mindful we've got a BSL signer who's been signing for a very long time now, and actually, and I'm mindful that we probably haven't got to everyone's questions, but I know that John and Phil and Nikki will review those questions, and we can look at how we can provide answers outside of this session. I think there's some themes that have come through the chat that we're very familiar with and we're aware of, that the sector want kind of a response on, so absolutely we can follow those up outside of this meeting. I would just like to take this opportunity to thank our Fitness to Practice team, Jonathan, Phil and Nikki. I think it's been a really informative session, and hopefully it's kind of set a scene about our approach to fitness to practice and how we want to do things differently. And obviously I would urge people, we are doing some and my notifications are now going off. We are doing some employers workshops that are going to be advertised in April. So for those of you that are on the call that are employers, we'd welcome you to sign up for those. They will be advertised after Social Work Week. And obviously you can always contact the regional engagement team as a point of conduit for the for any fitness to practice concerns you want to have. So just like to say thank you very much on behalf of Social Work England, and hope you enjoy the rest of Social Work Week. I know that Julia's put a feedback form in the chat, so we would welcome feedback on this session. I don't know if it's now disappeared at the top, Julie, amongst all the comments, so I wondered if you can now perhaps repost that for people to add their feedback. Thank you very much, everybody.